any form of IP. You all are internal team members here. Anyone else? Yeah, speak up. I mean, let's keep it informal. So, it is very energetic when we have a two-way dialogue. Keeping on explaining things, one by one will not help. Yes, you have filed what kind of IP? You have filed a copyright. Yeah, you can sit. Copyright on your teaching material, your slides. Oh, you're from? Nashik. Okay. Anyone else? You all have an idea about IP, what it is. So in our daily conversations, we said, "Are tuza patent hai ka?" That slate has come out nowadays in our life. Okay. So what I'll tell you is what we'll be doing in the next 1.5 hours. Okay? First, we will try to understand what is IP. Okay? So what I will do here is I will give you all a basic idea about what are the different forms of IP, what they actually constitute as an IP. Okay? So what goes under each of this IP, and then we will try to focus more on patents. Okay? Because patent is a buzzword, and it always so happens that there is always you can say it's like Shah Rukh Khan type, kaitari tachat maja hai, that kaitari gammat hai. So we'll try to understand patents in that point of view. So I'll try to keep it as interesting as possible with certain examples. Otherwise, these topics, they are heavy with information, heavy with legal language, heavy with techno-legal things which are involved in it. So after some time, we try to doze off with the information that we are getting into. So we'll try, and then the second part, the last 15-20 minutes, we'll try to understand how a search is also done. See, because only filing of patents or filing of IP doesn't help. I come up with an idea, but if there is something which is already there in the market, so it's always as reinventing the wheel. Why do I work on it? See, so what I need to understand is if there is something there in the market, can I do it differently? Or, is my idea already being patented? So how do you find it out? Okay? It is not a general Google search that I put words and I get a patent out of it. There are techniques, there are various analytics which are available. So you all need to understand how information is retrieved. Okay? So this will be the first 1.5 hour session. I'll try to be on time. So let us keep interacting. You can stop me anywhere where you all have questions. Don't keep it till the end of the session because then we tend to lose out on what we have to ask. Okay, so essentials of IP. Now when we say property, property is either movable, okay, so it could be immovable property, a land, a building, or we have intellectual property. Now this is tangible property, okay. These two are tangible, this is intangible. Why we say intangible? Because this comes out of your mind. Okay? It is an idea where it is not in a form, or you have not given it any structure, but there is something in your mind, okay, and I cannot see it. Then in that case, how does this get protected legally? Okay, that is what we are going to understand in terms of intellectual property. Now, as I said, how do you define it? Okay, this is being defined by WIPO. It can be said, as I said, it is a creation of your mind. So some idea that is bluntly which comes out of your mind, and you are going to give it some form, you are going to give it some structure. Okay? If I put an idea in front of you, it's not necessarily protected in that form itself. It needs to be in some. So this fan, I know it moves, so air comes out of it. Okay, but then the structure of that fan, the angles of that fan, so that is something which is giving me that property, and because of that property, I am able to get air out of it. Okay, so it is a creation of the mind. This is an intangible property. It is an exclusive right. Now, what I mean by exclusive right? Okay, exclusive right is something which is granted to you legally. So I am the owner. I have this house. This is the land, and I am the owner of it. So I am an exclusive owner of my right. Okay. So in spite of this being an intangible property, you have legal rights for that for a time-bound period. Okay. And this is a territorial right. What we mean by territorial right is you can apply this right. I apply for a legal status in India. It means that I can enact this right only in India and not in the US. So that is what is meant by territorial right. If I want to enact my legal right in the US, I have to apply that application or that patent in the US also. Then I get the right in US also. So these rights are territorial rights. Okay. Now what we can do with this right? I have something and I am very proud that I have a patent. I have a trademark, I have a copyright. What do I do with this? You have a house, you stay in that house, so you own that property. I have a car, I drive the car, so I have, I'm using it. What do I do with my intellectual property? Okay. What all can I do with it? You can sell this intellectual property, so that we call as a tech transfer or licensing. Okay. So it means that I have a property, I have developed something, and I feel that this ma'am it will be helpful to her, so I sell it off to her for some cost. Okay. So I can also mortgage it, so it is for a time bound period that I can use it. I can also gift it. Okay. So I say that this is going to be useful for the common people for developing certain drugs. So instead of I putting in my cost or I putting up any royalty, I say I will gift it to the well-being of human beings. So I can also gift my property. So that is all about intellectual property, the basics of it. Okay. And the period, as I said, there is a definite period. So any government, when they give you legal rights for any kind of an IP, there is always a term which is associated with it. So if we say for patents, it is 20 years. Now she said she has a copyright. So it is 60 years from the life of the person who has filed for the copyright. And beyond that, if her next generations also wish to have, they can another file for another 60 years. So every IP has a different kind of definite period for filing. Now we will start with copyrights, because most of us are very well connected with copyright. So all musical tunes, all your films, you all must have read in newspapers that this one has created an infringement case on this because they stole my music and all this. So all this comes under the copyright. Now what is a copyright? Okay, or whom it is given to? A copyright is usually for your literary, dramatic, musical and artistic work. Now most of us, we might be having kids, of our college-going students who are very much connected to Harry Potter. So you can see, she was a very common lady who just came up with some book, and that book became $1 billion, marketing for her. So she owns the entire copyrights for this book. So no one can reproduce this book. No one can use anything from this book without her permission. J.K. Rowling. Okay. So I've taken common examples where we can relate. Okay, so what is literally dramatic and artistic work means? Any textual form which comes under literature. So it could be novels, as we said, J.K. Rowling's. It could be any poem. It could be plays. Now, when does a copyright come into existence? You have to register yourself that this book is written, say by Vidula, and I am the owner of this copyright book. Then in that case, your copyright ownership starts for the novels. Audio, so music, lyrics, speeches, you all must have heard, IPL is a very known tune nowadays, but they never copyrighted or they never filed any IP around it. So, it is open to use for anyone. So IPL tune, all of us, are used to that tune. Once we hear that, we know IPL is coming. That is how our daily life is being connected with IP. Dramatic works, films, musical compositions, choreography. So many of the films we know are being copied here and there. So they need to take permissions when they are copying up any piece of a film or any dialogues. Nowadays, the way Amitabh Bachchan is going to talk has also been protected. You all must have seen. So he has, certain words what he uses, or even Anil Kapoor's, what is that very popular word? Sorry? Jackass. So, he has said that no one can use it without my permission. So all this thing is, it comes under your copyright protection. So how do they do it? How do they implement it is a different story. So that we will discuss if time permits. Then any advertisement, maps, technical drawings. Technical drawings specifically mean your building drawings. You all have certain architectures which are very unique, and you feel that they need to be protected. It can be registered under copyright. Computer programs, algorithms. This is specifically for India. In India, we grant it as a copyright and not as a patent. Okay? Why it doesn't go under patent and what will be allowed under patent in terms of AI and software, that we'll see when we go to the patent section, and your databases. As we said, this is a statutory right. Statutory right is something which the law gives you. So this is protected legally. So anyone, can, you all can go and sue anyone if anyone is infringing your right. it is an economic right. So as I said, if I sell off something on my end as a copyright, my novel, I'm going to claim royalty on it. So I get money out of what I have created. And it's a moral right, so right to object any action or relationship with work which would be prejudicial to the, so you know, as I said, like if someone is using Anil Kapoor's word jackass, he can go and sue that person because it has been used without his permission. Okay, so that is, and negative right is, you know, where you don't allow others to use my right. So it is called as a negative. So if he wants to use something without my permission, he won't be allowed to. So it is called as a negative right. So it has a grey kind of a shade to it. Now when I say copyright and when I said it is infringement, what does infringement mean? Okay. Infringing is without authorized permission, I am using someone's information. So that is true even when you give out your property. So if I just go on staying in a property without a legal agreement between the parties, it means I am infringing the rights. Okay. Similarly, in copyrights also, this is true. So many a times it is observed that you go to theaters and people are recording on their mobile, or you know, the picture, the movie which is going on. So and then they use this to upload on the YouTube. So this is actually an infringement of the copyright of the director or the producer who's doing it. Okay. So nowadays you must have seen that any new movie which comes out, there are a lot of you know, care is taken that it doesn't get leaked out of YouTube. It doesn't go unauthorized to the viewers. Okay. So these all actions, or you know, this all act of using someone else's property without prior permission comes under the infringement part of it. Okay, anything on copyright? I'm going to just speed this up a little. I'm just going to give you the basic idea about what all is there. Yes.
What could be the reason that different IPs have different periods of protection?
Different periods of protection. This specifically for copyright, it so happens that the author has put in a lot of intellectually written material into a copyright. What happens in patent, I tell you. Specifically, patent has the least number of years of protection. It's 20 years from the date of filing.
Designs have
that is 16 years. So in India, we don't have a design patent. We have a design application. US gives a design patent. So we apply only for design applications. So Indian government, under the Indian patent law, it is not for patenting. So that is for 16 to 15 years is what you are getting. Now what happens in copyright is, you know,
question.
Yeah, I'll just finish with this and then, yeah. What happens with copyright specifically is, you know, that work which has been created by the author, it is not easily duplicable, or it has to be more efforts. In patent, how it happens, you know, there's always a chance of incremental step in that. So if I give it for a longer period of time, say for 60 years, no one will go into the thing of incrementally developing it again. Okay, now it is coming with AI. You see, the way patents have been granted nowadays is totally different than what it was to be done before. So with AI, every 2 months I get a new incremental in my invention or in my innovation. So that period is limited for 20 years. That doesn't happen with copyright, because coming up with one creative novel, whatever efforts he must have put in of 20 years, whatever he must have put in, for that it is that period of 60 years is being granted specifically for copyrights. Yes.
Ma'am,
You can say.
Ma'am, while reading the laws related to copyright, it was said that after the time period of the expiration of the copyright,
yeah,
it goes in the open source, so like
yes,
anybody can use it.
Yes.
So like, can anyone else apart from the author can put a copyright on that content?
I didn't get your question. Author is anyway the original person who is the owner of that copyright. So
yeah,
it comes in the public domain, as you're saying.
Yeah. So
yes,
like, can anyone else put their name?
They cannot. They can. Because it is there in the public domain, so now anyone, it is open to use of any common person.
So once it goes in the public domain, it cannot go back into the...
It cannot go back into the domain. That is true with all your IP. So even for our patents, we'll see how, you know, what prior art is defined as. So that time I'll give you a case study of Donald Duck also, you know, where it is a very sweet prior art story. So I'll tell you how it happens. Anything else anyone wants to ask? I hope it is like not too fast. Okay, now industrial designs. Okay, you all can see here I have put in pictures, you know, which are totally different. Now this is what can you all visualize out? The first one.
Smart band.
Smart ring.
Yeah, but it is attached to a ring. Okay. So a headphone which comes with controls on a ring finger, okay, is a unique design which has been produced here. Okay. Now why shouldn't the author get a design application or a design protection for this? Okay. So the concept of industrial design is here. Now I am giving you simple examples. It is not necessary it's going to be always this simple. Okay. What are industrial designs and what comes under industrial design protection? It is a shape. So you can see now this is a juicer. Okay. It has got a shape of a spider and you can see how uniquely it is extracting the juice from it. So the design protection is given for the aesthetic look. Okay. This is the aesthetic look for which it has been protected. It is not a feature, but it is a look, it is a shape, which is giving it that extraordinary feature for which this industrial design protection is given. This is the second form of IP, intellectual property. Now, how it helps? Because see, when you apply for any IP, you need to prove that it has a good feature in it. Okay? Just saying that this is new and I want an industrial design application will not help. The law will not agree on it. You all have to prove it that this is, yes, this is new and because of that feature, this, I can say, this is very useful because I don't need to carry a big thing with me. I just can put it on my ring and have those two, earphones, and I can control it just by, placing a finger on my ring finger. So, because of that feature, because of the appearance of the design, this product is becoming attractive and appealing, and it has a commercial value. Okay, so these three factors are very important. Attractive, appealing, commercial value by which it becomes marketable, and that is why I say I can apply for an industrial design. Now, industrial designs, there are, at the end of the slide I will show you, every product might have two IPs involved in it. Not necessary it is always only a patent, not necessary it is always only an industrial design. So one product, say this Bisleri bottle, it can have the outer shape, can get an industrial design, and could be the technology of forming this bottle by which water can stay for say 20 days fresh, can go under a patent. Okay? So this is how IP works. So it's not necessary that I identify this only as an industrial design. This can also get a patent. How this can get a patent? Say the ear pods which are connecting to my ring. Okay? There might be certain algorithms which is written, certain steps might be written in it. So because of that, I can also apply for a patent for the same product as well as for the design. Okay? So we'll just see a few examples. Now, you see the shape aesthetics. Okay, this is a normal soap. No, this is the one which we use. What the person has done, he has converted into some duct kind of thing. Okay? So I can apply for a aesthetical look of that soap. I get industrial design can be applied for it. Agronomically, you can see this is a normal pen. Okay, one simply which we write. What the user has done here is inventor. He has given it a hole by which I can grip. I can hold that pen. This might look very simple, when you look at it, because we are seeing that as an example. But when he thinks about it, when he shows the utility about it, you tend to get an industrial application or a design application here. Okay. Last is a simple pen drive that we see. Okay. Usually we think, what is there? It's like, you just created 5 different ports. But if you see from the usability point of view, a person carrying 1 and a person carrying 5. That is the difference. So it is the aesthetics, it is the utility and the agronomics by which one can apply for an industrial design. Okay. Now what can't be registered under industrial design? So it's not necessary that everything under the earth can go under the industrial design. So labels, your stamps, postal stamps, greeting cards, calendars, certificates, so your college certificates, these cannot be registered under in any industrial designs. Maps, specifically, country maps, they cannot go under industrial design because it is open to use for all, and all, it should be that way, so public should be able to use it. Your building, construction, real estate designs, flags, emblems, obviously you cannot use that. Parts of the article not manufactured and sold separately. So this is very important. And just a size change. So if this, as I said, the Bisleri bottle, instead of half a liter, I make it 1 liter, and then I say it is applicable. No, it is not. Because you are just changing the size, there is no aesthetic change. So that cannot go under your industrial design registrations. Okay, anything you all want to specifically ask upon industrial designs? Okay, geographical indications, all of us are very, using it very closely in our life. So, very recent one is Alfonso Mango, Hapus Amba. So that has all, Devgad Hapus it is called. That has got a GI tag. Rasgulla, there's a, if you all must have read in the papers, there's a fight going between Orissa and Kolkata to understand whether Rasgulla is originally coming from Orissa or it is coming from Kolkata. And both of them have applied for a GI tag. What is GI? So a geographical indication is something. This is not of the human mind, but it is of the origin of the place from which it gets that characteristics. Okay. So here I have showed Satara Kalmipeda. Okay. This is very specifically to Satara. Okay. Because of that place or because of that area, it is getting that flavor or it is getting that specific characteristics. That is why it is called as a geographical indication. Puneri Pagdi, strawberries. Now you all know Mahabaleshwar is the best place. Why strawberries come so well in Mahabaleshwar? Because of the climate conditions, right? If you try to grow it in Pune, it won't get that flavor what is there in Mahabaleshwar. Why? Because of the cold, maybe because of the mud. So a GI is specifically disturbance because of this. This adding better? Is better? Hello. Yes. So geographical indications, what they indicate is, it is because of the place of the origination. So Darjeeling tea. Now, if you try to grow that tea in Pune or in Maharashtra, say in Delhi, it won't give that flavor of tea what you get from Darjeeling. So the quality or the reputation of that place by which this specific product gets its flavor comes under your geographical indications. Okay. Now, a geographical indication, who is entitled? So, like as we say in copyright, it is the author. As we say in industrial design, it is a person who has developed the design. Who can apply for a geographical indication? It either is the person, the producers, or the organization. So an entity as a whole can apply for a GI tag. Okay. Now GI tags, you have to prove that down the line you have to have certain paperwork in place to prove that down the line this was happening so many years. Because of that, this product has come and it is eligible to get GI tag. Okay. So there are many examples for GI which we have here. One is the champagne. It's very well known from France. So that place that it is gives that specific flavor comes because it has been grown in France. Those grapes, and then you get that is why it is called the champagne. The champagne word is also being tagged. Okay. This is the marble which comes from Rajasthan. This property, this marble, Markana, it comes from there because it has got those, only in that region you can get that kind of quality of that marble. So this is also being GI tag. And I said even Veer Kesar, Devgad Hapus, now as I said Rasagulla, all this have been, time and again now we are coming with new GIs which are coming up. Basmati, all might be knowing the case of Basmati, that is yes. Now, patents in India started coming. It was the basmati which was patented and also it has a GI tag. Basmati. So it goes to the organization. So as I said, it is the person or the producers who are applying for that GI tag. Okay. Now in case of Devgad Hapus, I tell you how it happens is Amba Samsthan Devgad Amba Hapus Samsthan. So like they are organizations in Amba. So they have applied for that GI. It goes to that organization. It has been granted to that organization, not to the government. If the government has applied for it, they will get it. So the person who is applying or the organization who is applying, under that the GI tag is given. Basmati was a very unique case, because there it was a patent also and it had a GI Same with honey. So it was a very specific case for which we had to actually revoke the patent. It is a natural property which comes there. Okay, so on GI, anyone else needs to have certain more things to do? Because I'm just giving you all the overviews. If you go, into each details more of infringement and everything, we may not complete whatever we have decided to. Now, trade secrets. What is a trade secret is something which no one knows. That is why it's called as a secret. So it is expected that no one should know what is happening. Best known till today is Coca-Cola. Okay? Even they say that your McDonald's is also, it has been whatever the formula of that cutlet, whatever they put into it is said that no one knows how they have assembled it. So it's a centralized location from where you all get those cutlets, and then it is put into your burgers. Okay? So Coca-Cola, they say, is a very well kept secret. Why one is, what do you all think, why one is motivated to keep it as a secret?
They lose their market value. If the
Sorry, I didn't get any answer.
If the secret is revealed, they lose their market value in the population.
More than market value, why would Coca-Cola, you think, will lose a market value? I mean, Coca-Cola has now reached at such a point that.
I mean, if the recipe is leaked, I can also make my product with the same recipe, and it will become competition. So where 100 people are buying Coca-Cola, 50 will buy mine and 50 will buy them.
It is, okay, that could be one. It is not always the marketing. It is your recipe, what you're saying, it is like unique. It might be unique, could be it is just a common ingredient of ABCD. We don't know. I mean, we thinking that is a trade secret. Mainly why they don't expose it, it is to keep away competitors, yes. But to create that attraction in the mind of a customer, that it is so well protected. That is how they do a marketing of your patent setting. I mean, of your IP and everything. Because when we go into tech transfer and all this, I tell you how know-how is transferred other than patents. Okay? Where it might be possible on one end that whatever Coca-Cola has developed as an ingredient, okay, say A plus B plus C, it might be very common. It might not be patentable also. So what they thought is, I'll put it under the taste. Could be one reason, and obviously, yeah, customers, it is to keep away competition also. Taste secret is always, as I said, it is most valuable, and it is the most valuable secret which that organization had, and it thrives on that. So Google is a very good example. No one knows till today what is the code which Google had written. You know how Google originated? How Google came up? Any idea about this case study? It was a student project, and they started off with MIT, Massachusetts, US. Okay? And they approached the tech transfer office there, where India was still coming up with the thought of understanding technology transfer. They were way ahead. And then they gave this code to MIT TTO office. MIT TTO office said, this is it's a useless thing, and nothing like this is going to work. And you are just leaving it off. Okay? These two people, these students, they started their own company. It's a startup. Okay? And then they put up this code, and then they gave us the thought that a search engine can be developed on which we can search and get any information on tips of a finger. And that is how Google came into existence. And after that, the MIT TTO office, they said that we regret that we did not invest in Google. Why this story? Because your entrepreneurship, when we discuss later, it's going to connect you there, and that is why the code which Google has written, the base code which gives, it's developing day by day. Now what we have AI and everything. So the first base code by which the concept of getting information together, and I type even ABCD, it will give me some 100 results. That concept or that thought which Google got in, they have kept it as a trade secret. So that is about trade secrets. Now, as I said, what is the information? What you need to submit when I say that I want to keep my information as a secret? The information must be shared in context to confidentiality. Now, how do you, the owner of the information should have made reasonable efforts under the relevant circumstances to keep it a secret. So it shouldn't be passed on, like the Chinese whisper. So I just go and tell her, she goes and tells her, she goes and tells her. So that is not acceptable when you are going and doing trade secret, when you are applying for a trade secret. So the techniques is, now I don't know, this might be a myth, which is a story also. They say that Coca-Cola, they have one big wallet, under that wallet they've kept that secret and all that. But that is, I think it is more of, just to keep us enthusiastically know that, what are trade secrets. But yes, trade secrets should not be passed on except for a group of people. Trade secret should be always kept confidential. It is not like patents, or it is not like other IPs where it comes into the public domain, it is open to all, anyone can access. That doesn't happen in the trade secret. This is the only IP which no one knows except the makers of it. This is the only IP. Now the next interesting thing is trademarks. Okay, so we see trademarks in the question. Yes.
So therefore, how can we apply for a trade secret? For example, how does the SSC actually give us that right, or assess that yes, we have something very unique and they give us this trade secret?
You have to prove it to them. See, in IP, I tell you what happens. It is always the onus of the person who is applying to prove to the legal authorities that this has been kept a trade secret for years to ground, and we are preparing this, say for Coca-Cola, whatever that mixture, that liquid, is being prepared by using this process, and we have not exposed this to anyone. So you have to show a documentation. All this is legal. So you have to have a backup of all the documentation, and you have to prove it to them that this has not been gone out to anyone. No one is using this formula. The taste of that formula, say of Pepsi, Thumbs Up, is totally different than what Coca-Cola is using.
So it has to be disclosed to the IP.
The authorities have to know. Yes, patent will come at the end. What I've done is I'm just competing with the other IPs because these are the general ones. Patent goes a little bit complicated because there is more of claims and there is more of legal, scientific and legal. So we'll discuss that more.
Is there any life period for this?
Trade secret doesn't have a life period.
Until it is disclosed.
Yes. Unless it is disclosed, unless and until you keep it as a secret with you, it remains. So down the generations, you can pass it on. Yes.
Imagine if I prepare the same kind of drink which exactly tastes like a Coca-Cola. Their recipe is a trade secret. Can I file my same trade secret? Because I'm not aware of.
You can file, yes, you can file, but you have to prove. You cannot because you don't know what they have filed.
Okay.
So you might be having an ingredient A plus B plus C plus D is what you have it. Say could be have some more flavor. You want to make it more sour. You don't want to, because Coca-Cola may it might be a little bit of sweetish. So you say I want to cut down on the sweet tinge of that. So you can always put it as A plus B plus C plus D, but you don't know what they have filed.
No, one more question. Like it is generally seen that once the tenure for any IP is expired, it goes into public domain. And as trade secret is like infinite time, what would happen if the people involved in the trade secret dies? So like
that is always a problem with the companies. So companies usually rely only on a very close-knit group when they have trade secrets. So it is only your core group, say of you 4 people here have developed something as a trade secret. Say you all are from pharmaceutical background. So you prepare say a certain drink which is energetic drink, and you say I don't want to file a patent on this. I don't want to go for any because once you file a patent after 20 years anyway it's going to come into the public. Okay, so irrespective like it or not, it's going to come into. So what you all 4 decide, you all are the core people. You all know the formula. So what we do is you prepare that formula and you just give it to your manufacturing company saying that just develop this into a drink. So it is the onus of the company and the core people there to keep it as a trade secret.
So what would happen if the V4 expires and the secret goes?
You have
the
to
grave?
pass it on to your next generation.
That
Those
is
agreements are different. There is a legal agreement which goes behind this.
Okay.
So you can also sell off your trade secrets. So your 4 people, you all decide to sell it to these 4 people.
Yeah.
So you all can have a legal agreement between you people and saying that you won't pass on from these to say the 3rd generation person. That is how it is. But there are legal documentations, legal agreements which go behind when you are passing on information.
Okay.
there is no period for protection.
There is no,
like
trade secrets are in
there.
perpetual. Yes. So it is on the company. So as I said, no one could develop a second Google. People did try to do search engines, but what affected Google is no one could. So even ChatGPT, even if it comes up, it won't replace Google. So Google is Google, and then other search engines. So concepts of search engine or something which is unique, they have to keep it as a trade secret. It might not be difficult to develop code, but still, yeah.
In case of food products, we have to show our composition and
Food products,
ingredients.
yes.
So in case of like trade
They
secret-
go for legal, only the legal department knows that. They have to disclose it here. The legal department knows that. Because it is the right of you as an owner to decide that I am keeping it as a trade secret. Because you have developed it, right? So it is your right to keep it as a trade secret. No one can force you that. But this might happen where, if you are going for drugs, specifically drugs which say, there's a cancer treatment or something of that sort, and it so happens that because whatever formula you have prepared, the mass or it is very useful to all the humanity. In that case, the government can interfere and say that you have to expose it and give its rights for others to manufacture. So, but that is, in cases where it is for a larger benefit of the people. Coca-Cola and all that doesn't make a difference. It's good you don't drink it, so that is how it is. Yes.
But can the same product or process be filed for a patent and trade
Yes, yes.
secret?
We'll see that. We'll see that in later.
Ma'am, if two different ingredients have their own patent, but these words they very unique way. So can we create a trade secret or
See, patented product can go under trade secrets. I said one, but trade secret is not possible because in your patent you disclose everything. Trade secret is nothing is disclosed. Nothing. So if you are patenting a product, anyway the public domain knows it. The moment you patent it, within 12 months to 18 months it comes into the public domain. Once your application, the patent application is published, any one of us can read your patent. Trade secrets, no one can. So you cannot trade secret or patent. Right? Because everyone knows it, then what is the point in having a trade secret? Secret is something I will not tell anyone. That's it.
Ma'am, in the case of the trade secret, is it always an individual or an agency or a company who owns the trade secret? Like,
Yes.
and if it's an individual, won't it affect its brand value if he leaves the?
That depends upon how you take it as a legacy. So, as I said, in Coca-Cola, there were two people who developed it. And they kept it as a secret. Now they developed a company out of it. It is up to you as an owner to decide whom you are going to pass it on. Okay. Trade secret is very specific. Why I tell you? Because it is man-centric. It is not like the other IPs where it comes open into the market later. So it is up to you how you want to pass it on. If you pass it on well, your company will always flourish. So it is always man-centric that you need to decide how the legacy is going to go down. Yeah.
And like if the owner is knowing the secret and now they have to manufacture, so how do they protect it from the ones who are manufacturing?
Usually how they do it, I tell you. Chitrayanchi Bhakarwadi. Any one of us have visited a plant here in Pune, below. If you go there, they are the masala जो जाता है चित्रांचा का Bhakarwadi चाट, some masala they prepared. That is a trade secret. Okay? I have visited that factory there. They don't allow you even to reach that point. Okay? They prepare that masala. What they have prepared, no one knows except for the 4 or 5 people who blend that masala, that Bhakarwadi. And they give it to the manufacturing belt where it is just rolled into. So the person who is working, say you are the person who is compiling on that manufacturing belt, you don't know what is the ingredient in it. That is the way they protect it. And that is till date, they say whatever is the flavor. Many people have tried Chitra's Bhakarwadi. Kaka halwa nahi kela, any kela, any kela. Food lokani. But that typical flavor which you get from Chitra is not replicated anywhere. They have kept it as a trade secret. So it is not easy for you, even if you are a person in that field, you know food technology very well. It is very difficult to understand what is the combination because they give it to you as one unit and they just say, put this into it, that's it. They will not disclose what is there inside. So that is how they have maintained that trade secret.
I have a question related to this only. As you said, the 4 people are involved. So, वो चार भी किसी को बोल सकते
बोल सकते हैं, but that is the thing, that is what I'm telling you. It is a secret and it is your human, what you call, internal instinct or something that you need to have ethics. There is, that's the, how it happens, I tell you. Now if we are today 4 owners, okay, I have to believe in you and you have to believe in me that we have it. There are legal documentations which are done in place, so they operate at a different level. How it is done internally in the team, how it is distributed, it is always kept as a secret, and there are legal bindings around it also. But mainly it is all human ethics on which they operate. So we'll go to trademarks. Trademarks is something which we look at and we know it is for that product. So I look at this M and we know this means McDonald's. Okay? I look at this half-eaten apple and I know what is that. So it is a visuals or it is a look of it. Even if I look at this green bottle here, I know this is biscuit. So because that thing has been gone into our mind for so long that green, that bottle, Nokia, that tune, that specific Nokia tune which we had, we could identify, yes, this is what. Okay. So what are trademarks? Trademarks are a combination of words. There are combinations of letters. There are certain drawings. There are certain symbols. There are certain audios, like I just said in the beginning. IP and tune. It has become so common to us now that any April comes and we know IPL is down the corner because they keep on bombarding you with that. Okay. Colors, which when we say NSN or Wipro, that typical 3-colored flag you can see, we know that what it means. So that is for trademarks. Now under trademarks there are different types of trademarks. Okay. It is not always the structure which is given. So the word mark is a text piece. Now you can see Nestle. The way Nestle is written, that line and that thing on the top. So that word form in which the word is written, Nestle, is given a trademark. Okay? And you all might be knowing how it is identified. You see a TM written. Ganesh Beard is a very common thing which we have seen now. The Ganesh Beard, what they have written, they have trademarked it 1978. They started the operations, and since then they have proved that we are the only ones. So any other Ganesh Beard will not be written in the same way. There are many people who operate on Ganesh Beard's name, but the way Ganesh Beard is written has been written. Same with Nestle. Service marks, these are usually used for banking. So we know that I means SAS. Okay? So that is how we relate to trademarks in our usual daily lives. And what I can say, these companies have made it a point that they have bombarded us with so many things, that we tend to recognize it. You don't need to just wake up and say, "Arey, I know this." Certification marks usually come with quality. So wool mark, on your sari is silk mark, that butterfly which comes, silk mark. So we know that this is authentic silk and which is being sponsored by the government. So that comes under certification marks. Collective marks is usually for members of organization. So ICICI, cricket board. Okay. And last is a device mark. So again I have taken the example of Nestle. This is the way Nestle is written, but this is a picture which they have devised. Okay. So that pigeon with its 2 babies is under the device mark protection. So this is how trademarks are identified. Okay. Every trademark has its own unique feature. You have to prove that this trademark is unique when you apply for it, and then you get a trademark protection. There are different forms which are available. So I just out of the blue I cannot say I want to trademark this. You have to tell why you have to trademark this. So the way I have written the words, the format of the words, the color, the dimensions, everything I need to mention. I have to apply to the patent office. I have to tell them that this is under this category. There are different classes under which you can do a trademark. So it is not a general class. There are different classes. So educational has a different. Now DY Patil, if you all have, you all must have trademarked that logo or something. So under the educational category, say class 35, class 40, whatever is applicable to you all. Under that, you all can apply for a trademark. Okay, then now we'll come to patents. So anything for trademarks? Yeah.
Just a hypothetical situation. If sometimes, the company is not working good and I am the owner of Nestle, just for example, and if the company is not working, so I'm just,
and you can sell. See, selling off, it is, I told you at the beginning, it's a property. I just can sell it. This is not a property which you can see. This is a intangible property, but it has a lot of value because this is come out directly out of a patent. So it has, though you cannot see it, its value is huge. Now I can measure this because it has dimensions. How are you going to measure how can you measure your idea? So that is why it has immense, you should know the value of an idea. See, now I'm getting a bit off, when I say tech transfer, we say valuation. Okay, how do I value my patent? Is what we now we are getting into all those parts. How do I know? I can say in square feet. I can measure this hall and say, okay, this is what 1,000 per square feet, 1,000 rupees per square feet, and then I can put a value to it. But when you do a patent valuation, or your trademark valuation, you should know how to value your idea or your technology or your innovation. So that comes, long ahead. We talk about it. We have, when we go to entrepreneurship. But that's why even if a company is not working, but a logo has that, I have the confidence. Say, Nescafe has a story. When Nescafe launched its coffee, they wanted to launch it. They wanted people to recognize it as a coffee brand. Okay, many of the hotels and they said it's normal coffee. What is there in that? No one was ready to buy Nescafe. 2 years down the line, they were drained off totally as a company. Then they came up with a new marketing idea where you might have seen Nescafe ideas, like it gives you different ideas. You become strong. That girl is talking to her father. I want to go and study separately. You must have seen all these ads, and that is how Nescafe developed a brand where if you see in your menu cards now, it is coffee and Nescafe separate. See, so that is how they have developed the brand. And that brand value which you develop, even if your company is not working well, just now, but the brand value is going to sell off to that other company and it is going to give them commercial gains. So now you must have opted, it's always coffee and Nescafe. So I can order it separately. It is not the coffee, it is Nescafe. So that is how they put it in.
Ma'am, for a trade secret,
Sorry.
for a trade secret and trademark, if you have your perpetual
Yes.
right.
Trademarks, it has, I'll show you at the end. It has.
So is it very expensive to maintain them? Because for patent we know we
Trademarks are not trademarks. I think it is around 6,000. Trademarks are
They're
very
very nominal
cheap. Yes,
to
yes.
maintain it. And
Your fees highest go in patents.
okay, still in patents.
Patents, because 20 years you have to maintain it, and then there are categories like if you're an individual, if you're an organization, if you're a company, how.
Even trade secret is not very expensive. to
It is not.
maintain.
There's an annual fee which is there. How much time I have? Okay, so patents. Patent is what I said, it is an invention, a technology, an idea. Why patents are so well looked at, or why? Because patents have a maximum commercial value which comes out. And within that period of where you have filed for a patent or you have maintained that patent, you all can gain maximum out of it. Okay. Now we will see, as I told you initially, this is a territorial right and it is for a limited period of time. Territorial right, as I said, within the country where you are applied for it. Now, why one should think of a patent? Now, there are many youngsters here, so as we were discussing in the vehicle, she said that, I have an idea and I go and do a presentation about it. So, is it right or is it wrong? From a professional IP point of view, this is totally wrong to disclose your idea even before patenting it. Okay? So, don't go, most of the academicians feel that everything should be published because I want more papers. That is the need of what is there for you people. But if you feel that your idea has a potential to become a patent, it is always suggested that go and file a provisional application first. Secure your idea, then go and publish it. Anyway, out of your patent, it's going to be published, but it should be secured on your name. That is important. It is like once it comes in the public domain, it is for everyone's use. Now, to file a patent is always a question which is being asked. So when do I know that my patent, I have an invention? So before disclosing the invention anywhere. Now I am talking to you people here, and I have an idea, and I displayed here onto you. So there are around 50 people, 45 people here. All these 45 people know my idea, okay? And that has come into the public domain already, and I cannot file a patent on it. It's as simple as that. Okay? So when you have an idea which is unique, you have the confidence that yes, no one else has tried it before, or it has been tried, but I am going one level above it, and I am trying to give more better value to that problem which has been proposed. In that case, keep it confidential. Put at least a PS. Now I tell you what is a PS and what is a CS. Then we come down to go down to patents. Secure it on your name and then go into the public domain. This happens when you all have thesis with the students, because you all are academic, when you are doing research and there is a lot of thesis ideas which come up. In that case also, before you publish a thesis, it is always recommendable that you file a patent first on the whatever research is being done, and then expose it as a thesis later. Now when I call it as an invention, because in patent it is not an idea, it is an invention. Okay? Why we call it an invention? There are 3 criteria in that. First, it should be new. This has to be novel. It has to be inventive. And it has to have an industrial application. This is by law. Okay? They need this by law. So what is novelty? How do I define novelty? Now this question of someone had asked about public domain, prior art. Okay? When I say it is novel, I tell you about that Donald Duck story I was telling you. Okay? There was, this is long back, I think 69 or something. Buoyancy, in physics we say that I drop something, it will come up on the water. Okay? So, a German inventor developed something saying that if you put balls through the pinhole of a ship, because of the weight of the ball or the buoyancy force, that ship will come on the water. Okay, this was his patent. This is a rough idea I give you, and he said this is going to be very useful because the ships won't drown in the water. This was long back when technology was not developed. He was very happy with the idea. He filed it all over the world. Okay, he went into the German embassy, went into the Dutch embassy, US, India, everywhere. India was not developed that time anyways. When he filed in the Dutch patent office, the patent office did a prior art search. Every patent office does a prior art search when he receives an application. So examiner also does it, and professionals like us also do it. They found out a cartoon or magazine of Donald Duck, where the Donald Duck, Uncle Donald and his 3 kids, so they had shown a picture where those kids were putting in balls in that ship, and the ship was floating. That was considered as a prior art, and the patent was rejected. Okay. So when I say novelty, you need to prove novelty, and the novelty has to be proved from the point of the person who is applying for the patent. It is not the patent office who has to prove it, it is you who have to prove it that my idea is okay. How do you do this? You don't discuss it anywhere. You have to make a check in the public domain stating that there is nothing similar to there in the public domain, and that is why my idea is new and I am proposing it for a patent. Okay? This is one criteria. Second is inventive step. That is not obvious. Okay? Now you people are from pharma background. There is something, some drug you are preparing. He prepares one, you are from the same field. Okay? I say whatever he has prepared, is it obvious to you? Being in the same field. Okay? So if it is obvious to you that he is preparing A plus B is equal to C, and you say what a big deal in that. I know A plus B is equal to C. What is new in it? What is non-obvious in it? You have to prove that your steps are not obvious. They are inventive. There is something new that you are putting to the public, in that field, in that technology. Only then will you satisfy this criteria of non-obviousness. This is the second criteria for getting a patent. Industrial applicability, yes, this is more simple, because any invention that you prepare has to have some application, otherwise it's of no use. Okay? There has to be a problem and you are solving that problem. So unless and until you are solving some problem, it makes no point even discovering that solution. So your industrial applicability comes there. Okay? Clear on these 3 steps? Yeah.
What if a particular patent, like if you do the scientific many a times I have seen this that after the prior art report it comes that either the product or the process is novel but not the invention. Because whatever ingredients, say for example I am making a cream which is having all the ingredients which are novel. So that's how I am getting the prior art as novel.
Right.
But the process of making the cream is same like a normal sopramycin cream. So the inventiveness or the non-obviousness is not there.
You have to establish it.
Yeah, so
You have to
how to
establish it.
go for the patenting in that specific?
See now, when you give this to a patent agent, usually finds it. We have to identify what can be. I'll tell you how we do. We identify what can be the objections which the examiner can raise on your inventiveness specifically. See, usually novelty becomes easy to establish rather than your non-obvious factors. Okay, depending upon your prior art. Where do you think the patent is protected? Which part in the patent? Claims. Claims is the legal part. So what you write in the claims is your protection. What you write around it is not what is protected. So whatever I claim, when I claim it in such a way that it comes over the non-obvious factor by which is stated in the prior art, is the skill of writing. So when you draft your patent, application, you should be sure what can be the objections might be raised when you go for inventors. Draft your claims accordingly. So there it comes a bit with experience. It comes with a bit of reading. You have to understand where an objection can be raised, and then you can have it. So a patent as whole is never seen. It is only your claim part, especially the independent claims, which get your legal protection. Whatever you have written there is your patent. Okay, this is a nonce test that I just explained to you. Novelty, as I said, so this is the scope. Now your what do you call this? Claim part comes this. This is the scope of my claim. This is very important. Now this is a techno-legal document. Always a patent is a techno-scientific document where whatever you write in your claim is going to define the boundary of your invention. Okay. So claim drafting is the main thing which tells you what your invention is going to be protected. One patent protects only one invention. Two inventions, three inventions are never protected under one patent, one invention. So when I say my invention is this, I'm writing, but I find a prior art like this is not going to be novel. But my claim is this, my prior art is coming out of it. So there is nothing in the public domain, as I said, for a dollar nothing. In that case, my claim will be granted, so will be my patent be granted. Okay. This is how your novelty works. I think I'll skip what amounts to novelty destruction because I've just given you one example of prior art. Now your inventive thing we talk about. Okay. See, I've given an example of a chair with a cup holder. There's a chair and it has a cup holder at the side. This is already there in the prior art. She invents one more chair where she says it is with a holder to hold water bottles. So is this inventive? This is obvious. Okay. So you need to understand a person who has general knowledge. It is very obvious to him, this is very easy to state. When I'm talking, it is very simple. But you have to prove this on paper, and you have to prove it to the examiner that this is not obvious. So he knows that I can hold a glass, I can obviously hold a bottle in my hand. What is the big deal in it? But so if he says, a chair which holds the bottle, and also could be a chair is movable for someone who is, could be he is physically handicapped, by which he can say drain of the water, or he can go and pick some additional feature he adds, which may not be obvious to his development. In that case, I can prove that this is not obvious. So she thought about chair, she thought about a glass, she thought about a bottle, but she did not think that this could be useful for a person who is physically handicapped.
So basically you are changing the utility of that.
But you have to prove it. So it depends upon what is your invention and how what is going to be the end user. Only thing is you should always remember that person who is skilled in that art shouldn't be able to replicate it easily. Okay. So I know, he knows he's from pharma, I'm from pharma, I know big deal here, he's just putting 8 plus B to C. So is that going to be useful? You have to prove that you are one step ahead of the person who is already there in this field for 10 years. So that is how you have to establish it.
Ma'am?
In case of PR and search, they only check the data which is available online. In some cases, the
Anything
data-
in the public domain. Anything. Your research articles, your newspaper articles, your presentations like this, anything in the
like traditional secret or ritual things that has come.
TKDL, yes, traditional knowledge, there is a separate digital library. So if you are filing in terms of a plant, okay, so plant extracts what are taken. In that case, they do check TKDL also. That is called as traditional knowledge digital library. This has been developed by CSI. So they do check there also, where they have scanned all our traditional knowledge right from Ayurveda and everything. All those references have been scanned in that database. And in case if you are going for plant extracts, for your patent filing, you have to have a clearance from National Biodiversity. So NBA clearance is very important. So that only then you can apply for it. So that goes in a different way of it.
So if I have a polynomial formulation, each individual ingredient is already known in the traditional data bank for a particular indication. But now I have prepared a polyherbal and I have means dose optimizations and I'm claiming this mixture in this particular dose is effective for a given indication. So can it be patented?
But you have to prove your efficacy in that.
Yeah.
If efficacy, see, if the normal dose as I take it as a tablet, if it's showing me 5% efficacy, but because of your intervention or your knowledge and your combinations or the process that you have followed, which is showing me 50% efficacy, you can get it. So efficacy matters in that case. The process that you have followed. Yeah.
Ma'am, seeing from practical point of view, if I'm making a modification in an already existing invention and claiming it for patent and it is getting accepted too, then won't it be wrong for the idea that I've taken from, like as I gave the idea for chair with a cup holder. You said if I'm adding another feature to it.
It should be, see, mere just changing the form doesn't give you a patent. Okay, mere incremental invention doesn't apply for a patent. It should be substantial incrementation in your invention. Okay, as otherwise we never would have got patents. Substantial in the sense that word substantial is a grey area where you all need to understand what is the definition of substantial. Now when she said she is preparing a tablet, it is already known. Say a simple thing of acidity. Okay, I say that if I take one tablet in a day, then my acidity is reduced to 10% only. But taking her one tablet, my acidity reduces to 90%. So that is a substantial increase that she has shown. So just mere that and doing it from A level to B level will not give you a patent. You have to prove an efficacy or substantial growth in that invention because of your intervention. You could show and it also differs. Okay, now you are extracting arsenic, for example. Okay, arsenic extraction is very difficult. We know all that. So if it is there, someone is showing 0.01%, and with your method, you are showing it as 0.2%. But being arsenic, and it is so difficult to extract, even that 0.01% efficacy is going to give you a patent.
Okay.
So you need to understand in what field and what level of efficacy you are showing. So that is how patents are granted.
So as per this, if I'm just improving an already existing idea,
It won't give you that. Only improving doesn't. You have to show substantial
improvement, then I can.
And then it also should meet your non-obviousness and it should also meet your industrial application.
Okay.
Patent is not granted only on one factor. It has all the three factors: novelty, inventiveness, and your industrial application. So your novelty is in the process that you are doing. A non-obviousness could be the efficacy that you are showing, so it is not obvious to the person who is already doing it. And your industrial applicability anyway you have to show it. It has to be applicable. Right? Industrial application is the last criteria here. So I develop a Velcro. Where do I apply that Velcro? Simple thing is in our shoes. Just remove it and this. So just developing this Velcro is of no use. When I show its utility here, it's of use. What is this? This is a sensor. Okay. Where I can use the sensor, say example wipers. So when it rains, I know very well you know that it is raining and my wipers should operate. So that is how the sensor is there. So this is industrial applicability. Okay. Now what we have seen, what is patentable. Under the Indian patent law, there are certain things which are not patentable, which are not allowed to be patented. Okay. One is, as we just said, just simple frivolous inventions like gambling machines and all that, it is not patentable. Discoveries which are already known in the nature and mere discovery of it by you is not patentable. It has to be new. Plants, animals, genetic modifications, yes, but you have to show that because of your intervention, it is giving some extraordinary features. So only then you can do genetically modified organisms. There is a very good case on this. What you can go and read. This is a Calcutta High Court case. It is very interesting. That was the first case where a GMO was granted a patent in India. So read through it. These are very interesting cases. They actually help you to understand law better. Medical processes, surgical, diagnostic, therapeutics, other treatments on human beings, they cannot be patented. Nothing related to traditional knowledge cannot be patented. Mathematical business models cannot be patented. And atomic energy cannot be. Because these are, as per the Indian law, these are useful to the human, as a human mankind. So it is not advised that it should go under any patent. So there should not be any exclusivity of this. It is like monopoly of having, I am having it, so I will do it. What can be patented? A process or a method can be patented. Someone asked me about product and process. I don't remember who asked me. Can a product and can a process be patented?
Process be patented. Siddhi asked.
I'll explain it how a product and how a process also can be patented. Machines, composition of matter. So you are putting A plus C plus D together. If it is new, it can be patented. New drugs, yes, we are siding on all that. Formulations, yes, and improvements, any of them, substantially. Okay.
Combinations, if it is having some, say for example, if it is using a part is using some traditional knowledge, say for example, Kesar or Haldi or somewhat like that, we are n number of products which are living in the market. So any such product if we are developing and that particular product is having a much improved efficacy as compared to that of the competitor which is available in the market, can that product go under the
Under TKDA, you cannot product haldi, you cannot do combinations of it. So with haldi, I am using one more plant extract, another plant extract. Because of the combination of the three combinations, you are getting some output, as you said, which is has an efficacy level better than what is already there. I am saying this only for a combination, not for getting out. In that case, yes, but you have to, as I told you, you have to submit an application to the National Biodiversity Authority to go for a patent application. You have to give the source from where you extract these plants, and you have to deposit that sample in the NBA authorized centers, and then only organize. This is very specific for all the natural plant extracts. You cannot, I felt I took healthy extract. Okay, then how do I file for the patent? Now this part, anyway, we will look into how to do a search. This is another interesting part here. Selection of the countries. Okay? Every country you file a patent, it comes with a cost. Natural inventors, we are from India, we have to first file in India. Then we can go and file abroad. Okay? When I say India, there is a thing which is called as priority date. So today is 11th of July 2024. I file today in India. When I go to US, the priority date will be considered as 11th of July 2024. Based on that, the prosecution will happen in US and I will get a patent granted in US. Even if the patent is granted in the year 2026 and I file, say, in the US in the year 2025, the life of my patent will be calculated from 11th July 2024 and not 2025. Because your priority date is always the parent patent from where it is taken. So in this, we being Indian citizens, we first file in India and then we go. Now, there are two ways in which a patent document is filed. One is provisional, one is complete. Why I say provisional, you all go first, you all have an idea, you have developed something around that idea, you want to just protect it initially, go for a PS. A complete specification, you have to declare everything in that. Okay? Right from what you have done, what is the best method that you are claiming, what is the experimentation you have done, any data which is related to it. So you all have carried out certain studies on that experiment in your formulation industry. So that all needs to be disclosed in your complete specification, and this has to happen within 1 year from the date of filing of the original application. These are the types of patent applications. So you all have a divisional. Ordinary is the one that I said. Divisional, patent of addition, PCT, and convention. Now what it all means? See, sometimes it happens, that I file the patent and I realize that, there is one more incremental step that I've done into it. So instead of filing a totally new patent on my existing patent, I just add to it. That is called as patent of addition. Divisional patent is, as I said, one invention gets only one patent. Okay? If the authorities feel that you are claiming two inventions, they tell you to divide it. So one patent will have one invention, other patent will have another invention. That is called as a divisional application, where we divide the existing invention. PCT, I don't know if anyone has applied for, you all have done PCT applications anyway. See, this is the easiest form for, this is called as a patent corporation treaty. Now, why this came into existence is, in order to reduce the cost of patent filing. So at one time, I can file into 10, 20 different countries through PCT. And I get a time period of 30 months to enter into each country. So I do one PCT application. In another 12 to 18 months, I can decide, depending upon the market, which countries I want to enter. So there are, I think, 150 different countries which are there under the PCT. So you can decide US, you can decide whichever country you feel is feasible and you can enter there.
If you file patent in India, then no one can copy it from all over the world.
No. It is not published for 12 months. So once you file a patent today, for 12 months the patent is there in the patent offices, the application. It is not published. Once I give an application that now expedite to the examination, and then after 12 to 18 months period, they publish it online. Then it becomes available in the public. Till then it was not there in the public.
And once it is granted, then also it will not be copied by anyone in the
They
world.
cannot, because there is there in the prior art. So no one can copy your application. But you are the exclusive holder of that for 20 years.
Why do I need to file patent in all the countries?
It is a territorial right. So if I file in India, you will not get it as a territorial right for marketing or commercialization in the US. So if I have a company, okay, who is buying your product, and where the advantage comes when company is buying, I have a patent, so you have an exclusive right of 20 years, right? So no one else is going to copy your product, no one is going to copy your process. You can sell it to that company, and he having an exclusive IP right on that. In the US, he can gain more monetary benefits for 20 years. That is how they work out. So this usually happens when you are doing for drugs. When a drug has a lesser life, it has only 50 years. Drugs you don't know.
Select the countries where I will commercialize the product.
Yes. That is always your benefit. So you don't have to pay extra. That is why people opt for the PCT. Here, the costing also reduces. And you get time, say about 30 months to decide on which countries you want to enter. It's not randomly, because what happens in the US, I tell you, they don't allow our attorneys to go and stand in their courts there. You have to have a local attorney. So you have to pay there in dollars. You have to pay in rupees. So it is always, even in case of EP is like European countries, there you have to enter separately to Germany, you have to enter separately to France. And there you need to translate those papers. So it is not English. You have to translate first into Germany, or you have to translate into French. So all that cost factors which come into it, you get a time for PCT applications. How you can enter. You were saying something?
Yeah. Ma'am, just a hypothetical question. Suppose I'm filing a patent in India, so like India ka processing speed is less for patent, and same invention someone else is filing after 2 months, and
You get the priority date first.
I'll get, even if it is.
That is why the priority date is there. The moment you conceive an idea and moment you say that this is workable, go and file a case. whatever is your priority date. So today is 11th and I say file at 12 o'clock, midnight, but that is on 12th of July. You are the priority person, so you get the bonus.
But-
It is first to file.
Okay, first to file,
First.
independent of the processing
Yes,
time.
it is always first to file. US initially had this first to invent, but around some 10 years back, they also changed to first to file. Only US used to have first to invent, where we had to, prove, like, you have to keep your diaries and everything in your lab to prove that, I conceived the idea first. But that was a very difficult thing to happen. So all the countries now are first to file. Irrespective of, it would be I thought of it first, but I filed it at 12th of July, I lose my priority.
Okay.
If I went for, I'm a person who had, say for example, he is the owner of a company. He worked for the technology transfer and now he sold to me.
Okay.
So now I don't want that after 20 years it is going to be available in the public domain and the competitors are going to use it. So instead of that, all the information which is available in the paper and which is important for the population, can I include a trade secret for that specific information?
Then you cannot disclose it in the patent, right?
Okay, but it has
Know-how,
to be-
yes. There is a thing which is called as know-how, where the know-how can be kept as a trade secret. The process can be kept. Know-how is the factor which is given that combination or edge over the others. Know-how you can transfer it. That know-how has a different agreement. What is the know-how that is being transferred for what period of time, and on what basis you are going to claim royalty on the sales, or it's going to be upfront payment. That you can do. Know-how can be kept as a trade secret. But it depends on how you are drafting your claims, and if there is any factor by which you need to disclose that know-how, then it comes to the law. But there you have to file in that way. The formulation specifically. Yes. So these are the jurisdictions where in India we can file, Mumbai, Chennai, Delhi, and so if in Gujarat, Maharashtra, Madhya Pradesh, you can go and file the main office, that is Mumbai. There's a patent office. This is, I told you, the prosecution chart, how it starts, and 18 months, 48 months. So this all, a patent agent usually takes care of all this, because he is authorized to file a reply to FER, that is the first examination report which the examiner gives. See, this is all like an exam, and this is very legal. So you have to follow these guidelines, you have to answer all the queries which come from the examiner, you have to do it in time, else your patent gets abandoned before time. So only once you follow all these processes, everything will get done. Yeah.
If the patent is published and after that I want to go for the PDC application, is it?
PCT application. PCT application, see, once there is a time period. So within 18 months of your first filing, you have to apply for the PCT application.
Yeah, but within 18 months patent
You
is
have-
published and then
yeah.
I can go for the.
You can. Because you have already protected your priority date.
Yeah.
So today's date is fine. After this, within 1 year, 18 months, you have to enter into the PCT. If you don't do that, it is abundant in those cases.
But we can do that.
Yeah, you can. So these dates which I mentioned here, they are very important.
Okay.
These time periods are very important. So even if you say you file your provisional today, and so today is 11th of July 2024. By next 11th of July 2025, you don't file a complete application. You file a provisional, you don't file complete. Your patent is there in the public domain, that it comes out, and you lose your patent. So that time frame is very important. Within that 1 year, you have to go for a complete PCT. You have to file for a PCT. Okay, so with this, how much time I have?
Last question.
Yeah, only now I will skip out on search because we are short of time. Yeah, because we have to also talk about policies. This is just a summary about the terms, how much it is granted. So patent 20 years, I said copyright 60 plus, trademarks 10 years, and you have a renewal fee. Industrial designs is again 10, further 5 years you can extend it. And geographical indications, it is 10 years. Simple example of like one single product with multiple IP. Best we are connected to our phone. So you can see how it is. Trademark, it goes to the logo, ringtones, copyright is your software. Patent is the data processing method, imaging techniques. Industrial designs, as I said, the shape, the look, everything is there. So one product can have multiple IP. You all need to identify on your product what is applicable and